For here on Morning at NTV, an analysis of the Supreme Court ruling against the court-martial, executive interference threatening Supreme Court ruling. Who is the boss of this country at the end of the day is what the layman would be asking themselves. I am Priscilla Regina Naluoga. Welcome to our Kickstarter this Monday morning. Now, last week the Supreme Court did deliver a ruling on the trial of civilians in military court-martial, and the ruling went against the act which has been marking a smiling beginning for 2025 year by the people from the judiciary. However, in an open letter to Ugandans, President Museveni says he, quoting, very sorry to hear the wrong decision by the Supreme Court in the matter of the firearms and armed civilians being tried in the military court-martial. I know that many of you have been able to extensively engage with the President's response to the Supreme Court ruling. Well, this morning we do even give you a more extensive analysis with those that are observers of the Constitution and governance in this country, in the legal fraternity, as well as those that are meant to be protecting the voice of the government. Ladies and gentlemen, we're joined by ladies first. Gentlemen, you will excuse me, Sarah Bireete, Executive Director, Center for Constitutional Governance. Good morning to you, and it should be a glorious morning where we are sitting right now, a pivotal moment for the country.
Well, it's a pivotal moment. I don't know whether it is glorious, but we have a good test for the Supreme Court decision, and that is Besigye's appearance today. In which court will he appear? Will he be set free? So the country is waiting to see whether government is going to respect the orders of Supreme Court starting today. Okay.
Godber Tumushabe, a political analyst, this morning has been appointed as one who may speak in favor of, but we will wait to see which side he will fall. So I will not preempt, but good morning to you and welcome to the show.
See, I think you guys are trying to be provocative. I will take it, but yeah, but a great pleasure to be here, and good morning, our viewers.
Are we moving in the right direction?
You mean in terms of the Supreme Court judgment? No, I think that my overall view is that this is an anecdote. I think it's pivotal in the sense that if government of Uganda, as is constituted now, understood that it is here for the people, it needs to respect the dignity of citizens, it needs to respect the rule of law, this would be a judgment that can change the trajectory of governance of this country. Now, my experience, my personal experience with the current regime is that it's really a regime that basically actually will flip-flop all the way, and that is even evident in the president's writings, even when you have, you know, in as much as he's entitled to an opinion. Yeah. You can sometimes you can feel like these are institutions of government, of state, that respect each other, but right now the current environment is that there is so much uncertainty. All right. That you cannot be sure of how all these different institutions will act, and whether what we have basically changes the current trajectory or whether we are still in the same long jump.
Counsel George Musisi, the Supreme Court ruling does cover clients that you are representing. Good morning to you. Welcome to the show, and your quick translation of where we are today.
Good morning, Priscilla. Good morning to the viewers and my friends in the studio. I think it's a breath of fresh air, the judgment, and I think it's a step in the very right direction. The debate on trial of civilians and court-martials has been on for a very long time. For a very long time, it even goes way beyond goes way beyond the last election. I was reading the book by the former Chief Justice Katonga, and was saying that even when he was Attorney General, the President was always pushing for the civilians to be tried in the court-martial. So I think for quite a while, Mr. Museveni has wanted to use the court-martial as a tool which he can use to fix political opponents. Leave alone the things he's writing about Karachunas only regarding court-martials. Because if you look at, yes, court-martials handle Karachunas, but a number of people, I've represented over 500 people who have been tried and remanded in court martials. Of course, they have not gone through full trials, many of them. So, and many times we've been asking courts that look at this, when the rights are on the wall, where is the judiciary to stand up, to breathe life into the constitution, which is the key role of the judiciary. So it was such a breath of fresh air that the Supreme Court spoke so loudly, spoke so clearly, and I think with all the problems, I don't want to imagine that all the problems have been sorted, but at least for the judiciary and the Chief Justice Dolo, he has given Ugandans his retirement gift.
All right, that retirement gift had a statement in there where it said it can be taken up or not, some of the recommendations that he was giving. But we'll analyze what that statement means later on. But 31st January 2025 is definitely in the books of history as we speak. The Supreme Court holding military courts lacking jurisdiction to try civilians and ordering officials to hold any ongoing military trials of civilians and transfer them to the country's civilian court system. But of course, stopping short of declaring past convictions under the military courts void. It begs the question, what is the translation of this one significant ruling in regards to the judiciary and regards to constitutional observance for our country and the rule of law by and large, especially in line with the fact that we are entering officially into an elective cycle? I'll start with the constitutional observer.
Well, the Supreme Court ruling reinforces the rule of law in this country and constitutionalism, and especially protection of fundamental rights and freedoms. Under Chapter 4 of the Constitution, a right to a fair trial, and the question of non-derogable rights, where the right to a fair trial falls. So we have had a situation of more than 2 decades of subjecting civilians to military law or martial law. And the president on several occasions, including the letter responding to the Supreme Court decision, has always indicated that he prefers military justice as compared to normal justice under the Constitution. So we have been having a dual judicial system of martial law for political convenience and constitutionalism. So it's a breath of fresh air for the Supreme Court in very clear terms to have solved this controversy that has been around for more than 2 decades in the country. You will note that in recent times, from the time Kanokiza Besigye declared his candidature, I think that was the time we heard of court martial, a political leader, in 2001. Court-martial him. After that, his famous 1999 document that he had issued about the wrongs that were going on in the regime. Right from then, he was a serving soldier. Attempts to court-martial him then were stopped. After so much movement, we used to see delegations from Rukunjiri, delegations from church. Save the person, don't court-martial him. And from then on, it became a norm for political opposition to be court-martialed as a tool for political operation by the president. So we have had, even after the fracas in Arua, Honorable Chaguranyi presented in the military court. Then after so much outcry, changed. We don't even know the outcome of that case, of the stoning, the so-called stoning of the president's letter. But and then from then on, about, I don't know how many NUP supporters were rounded up, young people, 18, 19, court-martialed. Then the orders to force them to agree to crimes they didn't commit, charge them 3 months, then a presidential pardon the next day, all politically stage managed. But the crisis came after Besigye's abduction from Nairobi, with the state claiming that guns in Nairobi are a monopoly of UPDF. Somebody leaves Uganda today, passes through the airport, a public figure, he arrives in Nairobi, after 30 minutes he's kidnapped.
With guns.
With guns from Nairobi, 2 pistols. He goes missing for 3 days, he resurfaces in court-martial. So you see that the abuse had reached the apex levels of court-martial for political convenience. So this outcry, in a way, helped deliver a solution. That the Supreme Court finally was able to understand the gaps, and they clearly outlined them. The gaps in membership and independence of the court, the gaps in the composition of the panel, full of non-lawyers, the gaps in the way they conduct due process. In the process also of Kizza Besigye's trial, we had a lawyer, Aaron Kizza, who is still in Kitaria prison. A lawyer charged with the contempt of court, 9 months, excessive and unheard of sentence of 9 months, when even the laws say otherwise. So all this was able to expose the nakedness of the court-martial, and finally delivered a solution in that landmark ruling, which should then pave way for promotion of rule of law in the country, for promotion of protection of fundamental rights and freedoms, for prohibition of civilians being presented in that court-martial, because everybody was a candidate, including my co-panelists here, for that kangaroo court.
Okay, all right. Godber, your opening remarks in this situation, especially in reference to the fact that it comes at the helm when Dr. Kizza Besigye and Obed Lutale are now meant to be appearing before a court today. Which court? We are yet to see which court they'll be presented to today. Ideally, by that ruling, they should be remanded as of now with the powers that be through either the DPP or the Attorney General or even the Justice Minister.
I think that there is a range of issues here, Priscilla, in the sense that when we look at this ruling, the judgment of the Supreme Court, first of all, I have to really applaud the courage of the judges in coming up with the judgment that is soundly reasoned. Because in some cases, our courts have become so complicated that for us as lawyers, you read the judgment and you ask like, did this judge actually go to the law school? But when you read the judgments of all the judges, you can see that these are reasonably argued with all the relevant authorities, but also placed in the context in which we are operating. And that's to say, even with the dissenting judgments. Secondly, just to build on the point that Sarah raised about rule of law and constitutionalism, what Ugandans need to appreciate is that rule of law and constitutionalism, these are cultures, they are processes, they are not events. So there is no single event that will tell you that this is a country that is ruled under the rule of law. You look at the practice. You look at the trend. The same thing with constitutionalism. Sometimes when there is a judgment in the courts in this country, where the courts pronounce themselves in a very progressive manner, then the regime sympathizers here normally come out and say, haven't you seen now what the courts have done? But these are anecdotes, and anecdotes do not explain to you that this is the character of the government or the people who run government. In law, there is something we call jurisprudence. Jurisprudence is established over time. So in other words, you have to look at the jurisprudence of the courts and say, are these courts that actually are always on the side of the rule of law and constitutionalism? The same thing with government and others. Thirdly, from my personal perspective, that in the current regime, the Museveni regime, has a record of violating the law. In fact, to the extent that even the one thing that you have to credit them for is that if they are going to do something illegal and they realize it is illegal, they then go and enact a law to make it legal, which we call rule by law. So in other words, you'll find if you are looking for the legal basis of their actions, you'll find it. But otherwise, they have a record of violating the law, of acting contrary to the Constitution, whether it is the military trials that Sarah talked about, the attacks on the courts. This has been consistent since the Referendum and Other Provisions Act. Then you have the record statements by senior army officers. The one called Magezi who said he was giving an official statement of the UPDF. If you had an institution like UPDF and it is solid and credible and it knows that its job is to protect the territorial integrity of Uganda and the Constitution of Uganda, that Magezi would not be in his position by now. And so when you see that you have these senior army officers who come out and talk recklessly and they still maintain their position, their command position, then you have to begin to sit back and say, so does this ruling, does this judgment make a difference? Because the evidence is that you have a regime that does not respect other institutions of state.
So could you answer that question for us?
Yeah.
Does it make a difference given how the president has responded and the army officials that you talk about have responded to the matter?
For me, I take a wait and see approach. Because on the one hand, it is progress that the courts have been able to very convincingly and compellingly state a case, the position that basically that trying civilians in the court martial is basically persecution. That's what it is. So, but in terms of the character of the regime that is supposed to then translate this judgment into action, that's for me, it's a wait and see attitude approach. The regime has no record for me to give you my analysis and say this is how it's likely to behave. Remember that besides the writings and the arguments by President Museveni that the court martial is very useful in our circumstances, he is the same person who has been consistently arguing that bail should be abolished. In other words, in his mind, every time he arrests you or his people arrest you, you are guilty. So you should be the one to go and prove your innocence. So when you have a president with that kind of mindset, you can never be sure how he's going to guide the institutions of state on how they should respond to a judgment like this one.
Councillor Musisi, as we adopt the wait-and-see approach, as far as the Constitution and the rule of law are concerned, with how the Supreme Court ruled on Friday, what should then be the following procedures, especially in the case of Dr. Kizza Besigye and Obed Lutale?
Of course, the judgment, like Godber says, is so detailed and heavy. In fact, one of the reasons why I voted them, it even goes beyond the initial case from which it arose, the Constitutional Court, the Constitutional Court judgment to cover Zuguruka, that the Supreme Court even went beyond. And coming to your question, there is something that Supreme Court did. There was a section in the UPDF Act which was annulled, which they said that if you are found in equipment which are a monopoly of the defense forces, and so many people, over 600 people, have found themselves in court martial just because of that. That you've been found with equipment which is a monopoly. When it comes to, for instance, NUP people, they range from t-shirts, from umbrellas, to water bottle, to berets. And the Supreme Court said, wait a minute. For an offense to be an offense under Ugandan laws, it should be precise. Priscilla should know that this is the behavior prohibited, such that you avoid it. If you have something vague, so for the Supreme Court to annul it, I think it was a step in the right direction. Now, the judgment gave different orders depending on different people. For the case of, first of all, the first order is to seize all forms of proceedings which involve civilians. Of course, Dr. Kizza Besigye's case is one of them. When it means seize, it means the court martials, as it is now, they don't have any business. they cannot remand, they cannot even discharge.
No.
They can't even release, because if you have no business, you wash your hands. The only thing the court martial people can do is to organize the files. That's the only business they can have on BCJ's file, is to organize and hand over to the appropriate authorities. Of course, it presents a dilemma, an administrative dilemma, in the sense that for Dr. Kizza Besigye's case and all other people who are remanded to specific dates, because I want to imagine that there are people who are supposed to return to that court today, others tomorrow, others other days. The prison, you are only in custody on a particular remand. You can't be in prison without a remand. If you're remanded to prison up to 3rd, like he was, then short of any other remand extending his stay there, he's supposed to walk home and his colleague. So the only issue that they have to do very administratively is, one, if they transfer the files in these courts, unlike court martial, it's the DPP to institute charges. And of course, it's not a takeover of the file, like some people think, because the DPP is supposed to institute fresh charges. The other charges are not instituted by the DPP. The DPP is supposed to work independently. It's supposed to work guided by the law and the evidence on the files. So DPP may decide that to charge either a less fair offense or a more serious, or to drop the charges. So all that has to be done before before tomorrow. Short of that, he has to be released. He would be in unlawful custody. Now, for the case of others, of course, there are others who don't even have particular dates. There are others who, like Aaron, who were convicted but have challenged the sentence. Those people are supposed to, they can move court for particular release orders, these ordinary courts, because the court martial as it is now has absolutely no business dealing with those people. Of course, very briefly, there are many people who tend to think that most of the civilians who appear in court martials are hardcore criminals.
No.
They tend to think that, and I see a lot of sentiments that, no, but if you are caught with guns, why should you come to ordinary courts? Actually, our ordinary courts under our laws have the capacity and competence to handle any case under the sun, even if it's brain surgery. Otherwise, if there's a medical offense, they'll say, let's say that be handled by medical counsel. If there's a religious offense, but even bishops, as you saw recently, the Bishop of Ruel, it goes to courts. So courts are the experts of all experts. Meanwhile, the other, you find so many cases in court martial of being found in possession of allegedly 2 bullets, 1 bullet, and you're saying those are hardcore criminals that shouldn't be dealt with in ordinary courts.
That you were planning to overthrow a government with 2 bullets.
With 2 bullets. Even the way the charge is stated. For instance, if you look at Dr. Kizza Besigye's charge, how do you say that 2 people are found in possession of 2 pistols? How were they holding them? Were the 2 pistols too heavy that they were being held by 2 people? We've had 48 people who were found allegedly in possession of 4 bullets. So you wonder how were the 4 bullets being held by 48 people? So it's so laughable, but serious. And people spent 6 months in custody over such a frivolous charge. It's as frivolous as the one Sarah was talking about of Arua, where 34 people held a stone and hit the president's car. I don't know how big the stone was that was carried by 34 people. But those are some of the frivolous charges that can be found in the court martial.
All right. In regards to rights and freedoms that, Sarah, that you were talking about, of course, for many years you have shown us that through the lenses of history, this is not the first time, especially for those that are opposing the government or are speaking against the government. And it begs the question, is this constitutional ruling giving human rights defenders a win to hold on to and fight moving forward?
Of course, it's a very good decision. Like my colleagues have said, very detailed. And it does not stop at orders. It gives recommendations. I read the president's response where he says they are positive recommendations. But although he dilutes the judgment saying it is wrong, we should be mindful of our history. And as I read the president's response, referring to the, judges don't rule the country, it's ruled by people, I wondered, one, you have to give the president the benefit of doubt, because he said he was briefly given a telephone call. Maybe he wasn't given full details on the background of the judgment and how it's anchored and entrenched in the Constitution. The Constitution has two articles, Article 1 and Article 126, where it refers to the sovereignty of the people. Power belongs to the people who should exercise it in accordance with the Constitution. But Article 126, judicial power is derived from the people and must be exercised in accordance with the Constitution, but also wishes, values, and aspirations of the people. So when the president attacks judges, he is violating the power of the people. He is violating the Constitution.
Of course.
And people need to understand this. So when you say judges don't rule Uganda, the people rule Uganda, but judicial power is given by the people. So the judges derive their mandate from the people, not from anyone else. The people and the Constitution. So it's wrong to attack them in that manner, and that's an attack on the Constitution. So when you say that the people will decide how they want to be ruled, the people decided. And it's what the judges are using to rule. So I thought that maybe in a rushed manner of a telephone call, the president wasn't given this background, maybe. But when you look at what he proposes, I think what needs to be done, one, respect and uphold the decision of court, but also court gave advisory. Amend the UPDF Act and follow the advisory of court, or even make it better.
If I can give a rejoinder.
Before you join in, we're going to be taking a short break and pick it up from there, because now I know we are opening up a can of worms. So Godber, I'm going to ask you to hold your water right there. We'll take a short break. We'll be returning shortly. Welcome back to Morning at NTV. Our Kickstarter looking into the Supreme Court ruling against court-martial executive interference, interfering with the Supreme Court ruling. And of course, my pundits this morning have done a good job so far setting the pace and the stage for today, also being a significant day, the 3rd of February 2025, the day upon which Besigye and his colleague Rutale should be walking out of those prison doors if there's no other remand order to retain them in there, as of course we were also informed that then should things be done as quickly as possible, then files be transferred to courts that be, and fresh charges be dispensed upon him and his colleague. For now, they should be walking free in the ideal situation. We await to see how ideal that situation will be translated into the reality. Sarah Bireete is joining us for this discussion. Godber Tumushabe was also giving us his reactions to a comment that Sarah had put before, and of course Councillor George Musisi is amidst us for this debate. Godber, you were still giving us your input to...
Yeah, I just wanted to comment on the point that Sarah raised on the president could have been misinformed or misadvised given the time. I think that the president is a victim of his own inefficiencies. Because you see, when you put wrong people in the wrong jobs or in the right jobs, or you demobilize institutions, you reconfigure institutions that are supposed to do certain jobs, then you get the wrong advice. Because I believe that the Attorney General's chambers, which is supposed to be a core institution of state, which is supposed to be the harbinger for the protection and promotion of constitutionalism, has been abused over time. That the Attorney General's chambers, which is envisaged by the way under the Constitution, should have been the institution that gives the president advice on issues of constitutionalism and the rule of law. And for over the years, it has instead acted as a cheerleader of the regime. So in other words, the guys who are in that office operate as if that their job is just to protect the regime against accusations of breaking the law. Instead of advising the government, they basically, it's almost like pushing you. You push the government to do the wrong thing. They misadvise. Because if anything, a person who is a lawyer and you are the Attorney General, and it doesn't matter whether this is Chiwanuka Chigyowa or the late Nyombi, there have been several of them. They would be the last people to advise the government to appeal a ruling of the Constitutional Court. in the case, like in the case of Kabazi Guruka. I think that the person who made that decision to appeal didn't do any favor to the government. So President Museveni needs to understand that by weakening and dismantling these institutions, he becomes the victim. So you don't need to sympathize with him.
How does he become the victim when he chooses to hold now the power of the weakened system?
No, Auntie, so you become a victim of your failures. You see, you become even when you are failing because of the decisions you've made, you are basically becoming a victim of your failures. And I think that's where we need to look at it. So I don't think that we should be looking at it. The way Sarah says, he was misadvised. No, you are bound to be misadvised. If you have wrong people in the wrong position, in certain position, that's unavoidable. Okay. Secondly, you see, one thing that we need to understand is that our problems as a country, they are not legal, they are not constitutional, they are political. I can guarantee you that even without any constitutional amendment, another government, another president with a different posture on how they look at government, how they look at citizens, you can still use the same constitutional framework and run a country that is governed according to the rule of law, that is where citizens are looked at as citizens, not as subjects. Because you see, I keep on telling people that one of the things that we fear now is that you are going to be arrested. Then, of course, people like George fear they can be taken to the court martial because they have been there representing clients. But in principle, I have argued that when you walk out of this studio and then you go to the town and all the places and you see everywhere there are gunmen, there are soldiers in uniform holding guns. It's like this is like a war zone. Because I travel across all countries, including countries that have been faced with serious threats of insecurity. In most cases, you hardly see armed people. And I don't think that there are no soldiers or police officers. But in our case, I've said that in our case, Uganda, the current regime looks at Uganda, I think, is like this one big prison where we are all prisoners. The only difference is the levels of confinement. So there are those who have now been taken to prison. But if you look around you, and that is, you know, this situation happened under Idi Amin, even Obote one, where you would sit in a bar or at a joint, and then you have to look around you who is seated next. Or you are driving your car, and Sarah has the experience, you have to be looking in the side mirrors to say who is following you and for how long. Exactly. So that situation, that's living in a prison. So consciously, we are in a prison. And so the point I'm making is that ours is a political problem. And it has to be solved politically. You cannot apply legal solutions. So
what are the political solutions to this problem?
I've said time and again that the biggest the crisis we have is that the institutions of state, for a president who wants to remain in power for life, whether it is any one of us here, the one thing you have to do is that you demobilize institutions of state and institutions of citizenship. Once those institutions have been demobilized, the protection that they give citizens is removed. So the Attorney General's chambers, first and foremost, should be an institution that protects citizens. The Attorney General should lose sleep because the young NUP activists who are busy campaigning for their candidates have been arrested, they are lifted from Karanga and dumped into a court martial. If you are a serious Attorney General, you should lose sleep over it because your job is to protect these innocent citizens. These are harmless.
But they're not innocent. Harmless. They are NUP supporters. By that tag alone, they lose their innocence.
That's the point. Yeah. So the Attorney General's chambers, the courts, the DPP, and all the other institutions, you are working for the people, not for any political group. That's why some of those institutions
Councillor George,
some of those institutions are
you've
given.
Had the submission of Godber there. We're looking at opposition members here. You do have clients and NUP supporters that are behind the bars, and hopefully maybe you can have a gain for them in this situation. But also looking into the elective season that we are in, you're going to get more clients because the Attorney General's office is not here to protect NUP supporters, but other supporters maybe, that being the case. So where we are looking at right now, the posturing of the president and the army in regards to what was passed by the Supreme Court, warning that some of these things will not stand as far as they are concerned and with the powers that they hold. What does that mean for the Ugandans, who we should be thinking 45 million Ugandans, but if they're wearing red, they are not counted of the 45, therefore are not permissible to enjoy the rights and privileges of, being cared for, looked after by the Constitution and the law?
Of course, one of the reasons why I'll still go back to that judgment, why we applaud it, is if you look at the duty of the court in a democratic system, even in our fragile democracies, courts are supposed to stand between the oppressor and the people. That's why many times some of us have been used harsh words towards the judiciary, that despite all these things going on, where is your voice? And this judgment alone, first of all, is good enough. Not entirely, it doesn't solve all the problems, but it's good enough. It's a step in the direction. Because even during apartheid, there were many people who would be released. There's a lawyer called Sidney Kentridge. He represented so many people during apartheid. So even during apartheid, there was some semblance of a judiciary, which was fairly independent. Now, where does this leave us? These posturings of the president and the army, they are nothing new. Maybe they are just more open about it. And I want to agree with Godber that it's purely a political problem, that the more we are steeped deeper, the more the NRM government is pushed to the wall, they just bring out their ugly fangs. Yeah, in 2005-06, when Dr. Kizza Besigye was arraigned before the court-martial and charged with, meanwhile he was facing another trial in the High Court, and he was charged with having a rebel group, PRA, in the court-martial. The court, these civil courts, stopped the other trial. The first comment from the chairperson then, God rest his soul in peace, General Tumwine, was that we shall not respect the court rulings. And if you go to Google, there is a Daily Monitor story where General Tumwine says we won't respect the court ruling. We shall go ahead. Of course, eventually, normalcy returned. When 2009, when the Buganda ministers, including Wechitiwa Maiga, Honorable Namboze, Honorable Segona, were arrested, the first thing was they wanted to charge them with terrorism and treason. And apparently a meeting was held with General Sejusa, the IGP, then Mr. Kayihura, and the DPP. And the DPP said no, who is now the Deputy Chief Justice. So they have always loved to use the army as a coercive force. They have always wanted to disregard the law. They have always wanted to weaponize the law, to say you are in legal custody. But when you look at the charges, when the charges are frivolous, it goes back to, we all remember the NUP president and the arms which were paraded by the police, including AK-47s.
And then disappeared.
And then disappeared. They said, we found these arms in this room. So the using of the law to fight political opponents is not new. It's only that now they are more open about it. So I don't, the reaction of the president doesn't surprise me, or of the magazines of this world. However, like I've said, what do we want from the judiciary? The judiciary spoke, and with the reason that it's coming from the Supreme Court, I hope it can have a ripple effect to even the lowest grade 1 magistrate. That no, my duty is to do my bidding. My duty is to interpret the law regarding the facts before me. The rest, it's good enough that there's a court judgment. Whether it's respected or not, it's good enough that there's a court judgment. Let them disregard it like they have done to so many others, but then it will be a duty of the citizen, because court judgments are not self-enforcing, but it will be the duty of the citizen to push back. But what we need from court is to be bold, and the Supreme Court has done it.
Okay. Sarah, what are your recommendations to political opponents to the regime in regards to this atmosphere that we are currently facing, given the fact that it's just starting? We have, you said, instead of 365 days, we're going to have 800 days to come.
Will be very long.
Yes.
Because of the political activity, but also because of the brutal regime that treats political dissent as the highest crime in the country. In Uganda, to support the Honorable Chagulanyi, you would rather do any other crime than support Honorable Chagulanyi. That's the mentality of the NRM establishment, led by President Museveni. So that's why he's crying over military courts, because that was his solution for managing people who don't support him, not for keeping law and order, like he's trying to sugarcoat it using Karamoja. So the message, first message is for courts. We are very happy with the justices of the Supreme Court. We hope this leadership will trickle down, like Council Musisi has said. But my message also to court is they need to think about their work the same way we go to doctors for treatment. If doctors manipulated their operations, if you went to a biased doctor and he gave you wrong medicine, he's doing an operation, he intentionally messes it up, what would happen to the people? It's the same effect that the manipulation of courts have on citizens, on enjoyment of fundamental rights and freedoms. They should do the right thing in a professional manner. Other organs of government, of course, the institutions of government, like Parliament, like Attorney General, like the constitutional organs that should protect the sovereignty of the people against any brutal leader, have collapsed. The only means of redress we have is courts of law. Sometimes they've let us down. When they do the right thing, we are happy and we celebrate them. But then they need to up their game at all levels and know that the duty to protect the liberty of Ugandans, the duty to protect the rights and freedoms of Ugandans, the duty to protect and uphold the Constitution is in their hands. And the second recommendation then goes to citizens. Court decisions cannot enforce themselves. We must make sure that the Supreme Court decision is enforced and respected by all organs. When you look at the doctrine of separation of powers, it is very wrong for the president to sit and write that courts have given a wrong decision. He has abused the Constitution. It's not his place to determine whether a decision is wrong or right. Article 99 of the Constitution is clear. His duty is to protect the Constitution and all laws of Uganda. Supreme Court decisions are precedents that have legal impact. So when you sit and say this is a wrong decision, what message are you sending to the people? If the president feels that protecting the Constitution is a burden, let him overthrow it and rule like Idi Amin. He has that choice. And if Ugandans agree with that, or they will choose to fight him the same way they fought Idi Amin. He has a duty to respect and uphold the Constitution.
Good, but in this regard, we then have to reawaken the conversation on constitutional reforms. What are some of those reforms on table right now that could actually serve as remedies of the current catastrophe we speak of this morning?
Unfortunately, I'm not one of those people who are very, very concerned about constitutional reforms now. Because you can have constitutional reforms that do not reform anything. That's why I said that Uganda's problem is a political problem. It's not a constitutional problem. You can make marginal gains by reforming the constitution and the laws, but fundamentally the structure of government in this country is what is at stake. The structure of government means that you have the three arms of the state that are functional. The executive, that it is functional, that we have a president who can be able to put together a cabinet that is smart enough to lead a structural transformation of how government operates. That you can have a president who is able to constitute the different agencies of the state. A functional government that you can have a legislature that has the requisite authority as endowed on it by the Constitution, that it can be able to check excesses of executive authority. The parliament that we have under the current speaker and even some of the others before it basically has failed in that cardinal duty. That to the extent that actually, even when you talk about constitutional reforms, because some of the regime sympathizers will tell you that actually there have been reforms to the extent that the constitution has been reformed to serve the interests of the president, remove all the constitutional safeguards against a life president. So the legislature is an institution that is almost no longer irrelevant for us. The judiciary is where, because normally when citizens are stressed, when there is a crisis, an institutional crisis that we have, the judiciary normally is like the last line of defense of citizens. So that's why, even while I applaud the Supreme Court, I don't have the confidence in the leadership of the judiciary, in the current Chief Justice. Because you see, the Chief Justice is not just a judge. The Chief Justice is the head of the judiciary as an arm of the state. You cannot sit back when Ugandans are being persecuted in the court martial. Ugandans are being shot on the streets. Ugandans are being arrested and kidnapped, and you as a Chief Justice, and you just keep silent that you are waiting for that one day when you give a judgment. I think that's where Museveni actually beats all of them, because Museveni has, for him, he knows his power. And he has been able to grab all the power that everybody else has. So that's why for him, he even has the courage to be able to write about and say, this is a wrong decision. As Sarah says, you as the president, you can disagree with the decision, but to be the one saying that this is wrong or right, you're just behaving like an academic, because that should be for the lecture rooms. Those of us who teach now, we should be saying, this is wrong, this is right. But for you as a president, whose primary responsibility, who swear every other 5 years to abide by and protect the Constitution, that level of arrogance of power, I call it arrogance of power, because you feel like you are so powerful, so everything else is under you. In other words, you are the law. In fact, what Museveni did in that letter, he was trying to proclaim a new law.
That's where he says the people he means.
Exactly, So he was trying to proclaim a new law. He's saying, you the Supreme Court, you can issue a judgment, but the law is here, and I have now decided what is right and what is wrong. So basically, what we need to be doing as a people, I have said time and again that the primary responsibility that we have, because the other problem is that sometimes when we are faced with a crisis like this, everybody talks about opposition. We all say, the opposition, especially for us in the elites, we say these opposition people are not serious. What? I just say no. The enormity of the challenge that we face, which is the elephant in the room, which is the capture of state and state institutions, requires our collective action as citizens to be able to liberate these institutions of state. So people like the Chief Justice, even the Speaker, who is the biggest cheerleader of the regime, I think they are basically they are hostages of the current situation. Okay. They probably need more help than us, the citizens, because they are operating like hostages in a situation where there is concentration of power in one person, and that person is able to use the power both in terms of coercion, in terms of instilling fear, and in terms of incentives, in terms of money. So that's the situation we are in, and that's what we need to resolve, and that can only be done by us collectively as citizens, not just falling on one group of people. that we normally like calling opposition politicians.
Councillor George, someone was of the view that perhaps if you had a taste of this regime yourself, you would be thinking differently. But are your thoughts differently right now?
A test in what sense?
That you face the court martial yourself?
Like some baptism by fire.
Perhaps you'd be...
Yes, first
before the court martial by representing so many clients, and sometimes you tend to think that even you, the lawyer, you're on trial. You've seen a televised version of when Dr. Kizabesi is there the last couple of weeks. We've gone through them many times. I remember when General Kazin was appearing in that court martial many years ago. There's a justice now, he's a justice of the Supreme Court. He was a private lawyer then. General Tumwine would start his court at 5 p.m. and lawyers would sit and wait from 9 in the morning. And then he would drive in at 5 and start court, listen to 2 cases and adjourn. There's a time we were waiting for General Guti. Then those days he was in Jinja. I think he was a commandant at Jinja. Yet he was a court martial chair. He drove in at 10. Then they said the chairperson has forgot his specs. So he drove back to Jinja. And we had to wait and court had to start at around 3. So sometimes you've seen the way the people are checked. At one point we were even denied phones. I remember asking the chairperson that, but a phone is a library. How can I represent someone? So it's a contextual issue that and Godber, I think, hit on it, that every time this government has been pushed to the wall in terms of, and it all comes from the overstaying, the life presidency, which was created in 2005. Because our constitution envisaged a president staying for a maximum of 10 years. So you find that there are other corresponding things, like a judge retiring at this time, electoral commissioners serving for a maximum of 14 years, hoping that no commissioner will be there for more than 2 presidents. But now, where you have a judge is appointed and they say can retire potentially at 65 or 70, but then you are not sure whether this man will ever go. So you're a High Court judge, but you are appointed at 50, and you would wish to be a Supreme Court judge. So you need to play ball in order to get promotions. Because it was envisaged initially that at most, even if you're appointed at 50, another person. So it all comes back to the political issue. And some of these problems we're having, the debates, can never be conclusively handled until the political question is determined.
All right, emphasis by the president that the power belongs to the people. We come back to analyze exactly what that means, especially in the powers of the president.
MorningAtNTV, bright morning. Stephen Imbido Chibuga coming to you from Katonga. This is the base of People's Front for Freedom. That is a political coalition that is under processes of getting named as registered as a political party. But today, the business happening today is members of the bench that are lawyers are getting here, especially those who are defending Aaron Kiza, those who are defending Dr. Kizabesi, retired Dr. Kizabesi, and as well as Obedi Rutale are here together with other members of parliament subscribing to PFF just to forge a way forward. From the jubilation that was in the Supreme Court on Friday, you would even imagine and think that maybe by now all people who are being charged in the military court will be out at least temporarily for now, but according to what we see, lawyers, legal brains are still scratching their heads to see what happens. And here I have Honorable Francis Mujiche from Buhweju, Counsel Godber Tumushabe from Kiza and Mugisha Company Advocates, but also Counsel Gordon Chijambu and other lawyers are in there, and others still continue to come here. They're going to be telling us what next, because up to now, those who are charged before the military courts are still under detention, and we don't know what will be happening. But for now, Counsel Godber Tumushabe, yesterday you visited Aaron Kiza. In which state is he?
Aaron Kiza is in good spirits, I have to say that. He's very well committed that his freedom will be given to him at last. It is only being delayed by the military court-martial people and the relevant people on reasons that we don't know as per now. But according to the judgment that was given on Friday, all people that were remanded who are in detention because of any remand warrant from the General Court Martial are illegal, null and void, and therefore these people are now in illegal detention, and everybody responsible must be acting to have these people freed and have their freedom. And if they believe that there are any other charges against them, if they committed any offense, then they can be taken to the civilian courts. But for now, Aaron Chiza and all the other NUP supporters, including the Karamoja people, including Dr. Vesija and Ajabed Rutare, are in illegal detention because their remands are null and void, because the Supreme Court was clear that every matter that has been tried by that General Court Martial, which they termed as a disciplinary body, are null and void, and they must cease with immediate effect. It means by the time they finish the pronouncement of that judgment, all the remand is expired there and then, and therefore they are now in illegal detention.
I've gotten you from the meeting that is about to begin officially. You are the lawyers today. What next? Because the only person there watching MorningAtNTV right now thought maybe by now we will see Dr. Besija telling other people who have been tried before the military court will be out by now, and it's not out, but that they will be maybe tried in civilian courts, or they will be out at least temporarily, and this is not happening. What next from here?
Yes, they must be out temporarily until they prefer any other charges against them in civilian courts. But you saw after that judgment, the president of this country issuing a letter, and I believe that's the reason these prison officers and whoever is concerned in the release of these people has not acted. I think they are following the orders of the president, which are also illegal, null and void, and the president's communication and letter is in contempt. And therefore, we are here to brainstorm and have our people released immediately and unconditionally until they can charge them legally and then present them in civilian courts. After all, they are presumed innocent under the Constitution.
Thank you, Councillor Tumushabe. Let me also engage the Member of Parliament from Buhweju, who is also a member of PFF. You members of Parliament, you make the laws. According to President Museveni, it thinks that maybe there should be there should be maybe an amendment. But also before that, you as members of Parliament, this should also concern you. That court ruling should concern you. And this maybe you could see some of members of Parliament on the floor of Parliament talking about these matters concerning law and human rights. Is this going to happen?
What has been going on in the court martial is a process of helping Mr. Museveni to detain people without trial. Because he could not do it directly and send you to Ruzira or send you to Chitaria, he would get you through a court martial. And now that the Supreme Court has clearly come out to say this process should stop immediately. We are just waiting for time to get everybody who is illegally detained out of prisons. And as parliamentarians, we have no mandate. The Constitution does not allow us to legislate against a decision of court. It's a constitutional provision that once a court has taken a decision, Parliament cannot legislate to fail a decision of court.
When there is impunity and abuse, what will happen from Parliament?
Whatever Museveni is talking about is impunity of the highest order. And we don't want to be carried with him in his impunity. But two, this is now Uganda versus Museveni. That the Supreme Court of Uganda representing Uganda, because judicial powers arrive from the people of Uganda, that now it is Uganda versus Mr. Museveni, who has decided to go against the Constitution, go against the judiciary, go against the Parliament, go against Uganda.
And if indeed he's going against Parliament and the judicial and the Constitution, will Parliament just look on as this happens?
Where we wait to meet tomorrow in Parliament and discuss a situation that we find ourselves in, where Mr. Museveni has decided to overthrow the Constitution, to overthrow the country. So we can no longer talk about any Ugandan who is attempting to overthrow the government. Mr. Museveni has overthrown it by saying, I don't respect the Constitution, I don't respect the judgment of the Supreme Court. If you cannot respect the judgment of the highest court in the land, then you have virtually overthrown the government. So we wait to see how it goes. But as a legislator, I am not going to be party to those who are going to escort Museveni on his journey to overthrow the constitution of Uganda.
Words of Honorable Francis Musisi from Buhweju. Thank you so much. Let me also engage Council Godber Tumushabe, who is also part of the team that is here in the meeting at Katonga, the PFF base. Good morning to you, Council.
Good morning. Good morning to
for you, what is your, what would you want to see going forward from here?
First, it should be on a public notice that the disciplinary body, as it was determined by the Supreme Court, is already in contempt of court. The pronouncement of the Supreme Court took effect on that day it was delivered. So from then to date, they're already in contempt. And the comments of the president are already also in contempt, because they intend to sabotage the separation of powers and the doctrine of rule of law. Museveni's directive does not amount or does not supersede the pronouncement of Supreme Court. The Supreme Court decision is upheld, and we are celebrating it because they simply made the Constitution to speak. The present comment of saying the judges do not govern this country, but it's a Constitution that actually made a pronouncement. So you should be able to respect it, and we want to caution the people that constitute the disciplinary body of the General Court Martial that we are intending to pursue them should they continue to try civilians in that disciplinary body. We are intending to pursue them in contempt of the Supreme Court decision in their individual capacity, because their actions are simply a self-importance overreach. They should respect the decision and hand over the file to the DPP's office, and we see that our civilians get their freedom.
Thank you. Thank you so much, Council Godber Tumushabe. Of course, earlier on I spoke to Council Godber Tumushabe from Cheese and Mugisha Company Advocates, as well as Francis Musisi, Member of Parliament from Buhweju. And as you can see, more lawyers, as well as members of Parliament aligned to PFF are just arriving here to forge a way forward on what should be done after that landmark Supreme Court ruling that happened on Friday. I have now turned you back to Priscilla Regina Naroga in the studios of MorningAtNTV.
All right, thank you so much, Stephen Bireete, for giving us the picture there at the Katonga Road offices of PFF. As we come back in studio, we want to analyze our final band, the powers of the president versus the powers of the people. In the president's response, he's quoted saying, anyway, the country is not governed by the judges. It is governed by the people, all of us Ugandans who are old enough to vote. In the matter of the constitution and other legislation, we govern ourselves by having a referendum, constitutional amendments, or amendments of the law by parliament. Some of those amendments by the parliament are the reason why he's still in power. So it begs the question, who are the people that are being referred to in this case, Sarah?
Well, when the president refers to the people, in most cases he's referring to himself. When he said the people had asked him not to retire, it was about him keeping power. When he says the people want court-martial, I don't know what people want court-martial. There's nobody who wants court-martial except himself. I'm sure even the soldiers who sit on that court watching sheepishly because they don't know what to do in a court, I'm sure they don't want court-martial.
Okay.
So, looking at the way, the first time the president attacked judges was after the passing of and nullifying the referendum law in 2000 that was passed without quorum. He was so angry, he even banged tables, addressing the nation in a televised, at least now he's writing and we are dealing with the document. The other time he called the media and addressed the nation and banged tables and said judges should concentrate to matters of chicken thieves. So his attack on judges, people who have watched him for long, is not new.
Okay. How do we cap the powers of the office of the president so that they can be for the people, to the people, and that is by the constitution that binds us all together as a country?
The constitution trims the powers of the president. We only have an overbearing president that does not respect the constitution. When you go to Article 99, executive power is derived from the protection of the Constitution. Actually, when the president fails to protect the Constitution and decisions like this one of Supreme Court, he loses his power.
All right.
So Ugandans need to remind him that unless he protects the Constitution, then he has no power and he should go home.
Godber, the Ugandans that are being referred to here are the very Ugandans that feel like if they decide to open up their mouth, they're going to end up in Chitaria, among other prisons. If they decide to go to the streets, as we have seen them going to the streets, they end up behind the bars. And the very same courts cannot really protect them. They must protect the regime. Then where's the power of the people?
First of all, I always believe.
Or how can we regain the power as the
Yeah,
people?
from experience, I've come to believe that if politicians truly believed that power belongs to the people, they would never say it. They would never tell you. So if Museveni truly belongs that power in this country belongs to the people of Uganda, he would never say it, because politicians are not known to say the truth. So in other words, the mere fact that they are saying it and the president goes and writes and says power belongs to the people, he knows that the people do not have the power. Secondly, the President Museveni says, oh, we can have elections, we can have referenda. Recently, he went on TV and said that in 2021, 1 million of his votes were stolen. Are those 1 million, are they part of the people who have the power? Because the 1 million of his votes were stolen. The opposition says their votes were stolen. So which power is he referring to? Which people is he referring to? Thirdly, right now what we need to understand is that the president rules with 3 instruments. 1 is coercion, 2 is fear, 3 is money. Those are the 3 things. Now, for every institution of state, many of these institutions have been instrumentalized to deliver coercion and violence. Okay. So the court-martial has been one of those that are overtly instrumentalized to be able to deliver that fear and violence. And I think that Ugandans need to understand that that power, that declaration in Article 1 has been overthrown by the current regime. So we have a responsibility. I think it's under Article 3.
3 years.
Under Article 3, we have a responsibility to protect the Constitution, to defend it and fight. In fact, right now, we should be, all that we should be doing, and I think that different people are doing their parts, the professional colleagues like George and others, who are there in the Supreme Court battling, who are there in the court-martial battling, the Sarahs who are in civil society arguing and educating people. They are all engaged in a collective fight to restore the power of the people. Okay. Unfortunately, we haven't won, but that struggle will be won.
We have 800 days to position ourselves for a win, the 800 days that Sarah talked about. So this time next year, Councillor Musisi says, you close this conversation for us. People have the power to exercise what they feel should be the right leadership, the right oversight over their country for the governance and democracy that we ought to be seeing, and is constantly recommended by the courts, by civil society, by the public over and over again.
Of course, governments world over, especially those ones in weak institutions, are always trying to push the people further, extend the tentacles of their reach by pushing the people. So these institutions like judiciary, like a strong civil society, like strong media, are supposed to be the bulwark between the people and that government. Sadly, of course, when they collapse so much, that's why you even hinted on it, that many people look at the opposition, say, what are you doing? What are the opposition doing? Ideally, there should be much more strong institutions, religious institutions. So that is bound to continue throughout this. It's even worse when it gets to the election season. It's bound to continue by pushing as much as possible. We know we have scars from the last election. It won't take one single institution, not a single party, it will take a collective push and realization of all Ugandans that we're in this together and we have to fight together.
Okay, speaking of being in it together, what steps are you taking moving forward when you leave here? What are some of the things that you're going to be doing in line with following up on what was ruled on Friday?
Well, I have a duty to ensure that the judgment is actualized. You know, the judgment, once judgment is made, it's in law, it's in rem, in the whole world. Even you, Priscilla, you can join me or ensure that it's enforced. So I'm going to join like-minded colleagues to see that the judgment is actualized. The first thing is to see that those files are transferred. If there is no movement from the court martial, we are going to file tomorrow for release orders, because there is no reason why the people should be in you know, people's freedom, and the Chief Justice hinted on it. It shouldn't be taken away casually. No. So people shouldn't sleep in prison for one extra day because government is too busy still organizing files or what. We talk about freedoms. In the meantime, they can release and then seek to organize themselves as people out.
Someone may forget the stamp in Barara. Anyway, it is what it is. We await to see how the 3rd of February is going to wrap up matters regarding Dr. Kizza Besigye's release and Obeid Lutale's release. So we await to see. Look out for subsequent bulletins or the hashtag NTV News for those updates as and when they're going to be coming in. As we wrap up Morning at NTV, we do have a birthday